This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
As promised, we're now joined by Todd Lutsky from the law firm of Cushing & Dolan. The segment is Ask Todd, and we've got the phone lines open so you can ask Todd your estate planning questions. 888-205-2263. That is the number to call to ask Todd your estate planning questions live on air. Usually we can only get through about 2 to 3 of these, so get calling early to make sure you get a chance to ask Todd your estate planning questions. That number again is 888-205-2263. We got plenty of room on the phone lines right now, but they do fill up. So again, 888-205-2263 is the number to call to ask Todd your estate planning questions. Mr. Lutsky, how are you doing today?
I am doing great. And yourself?
I'm okay. My wife asked me the other night why I didn't buy her flowers for Valentine's Day.
Well, yeah, that's a fair question. I mean, Valentine's Day and all.
I didn't know she was selling flowers.
Oh, well, I see. That's a fair
it's
answer, really.
Kind of a problem for me. Anyways, Todd, I want to talk a little bit about the idea of estate planning beyond the grave. And, what types of tools are available to someone who might have concerns about a child's spending habits or a child, maybe they're concerned about one of their child's marriages and want to make sure assets are protected for their grandkids specifically. What kinds of tools are available if someone has these kinds of concerns?
Yeah, and this is funny because I tell clients this a lot when we're doing estate planning. I mention to them, that, here's what the trust is going to do while you're alive. But oftentimes, I think, as you're pointing out, Chuck, that they can do a lot more for you even after you're gone. In fact, sometimes more than they do while you're living. So if you think about it, a revocable trust, you pretty much set it and forget it. Put your assets in, go about your life, and it really doesn't disrupt your life at all. Yet it provides all these planning opportunities and tax savings and probate savings when you die. Just happens. Well, when you're gone, the trust doesn't have to end. And this is your point, Chuck. They can go on for these family members, and oftentimes they'll say just that. These kids aren't too good with money. They're, I don't want them to blow through everything I give them right away. I want them to work hard. I want them to become, productive members of society, but use the money to better their lives, things like that. Absolutely, all that can be drafted into the document. And sometimes it's not even just that. It's not just about being bad spenders. It's about future creditors, whether it's a spouse's creditor that you had nothing to do with your family, but that's a problem if you're married. What if it's a divorce that could befall them? Well, they don't want to have to lose half of what you gave them. So these documents are designed to make sure that they're available for the children, perhaps even controlled and invested and managed by the children, but not owned by the children. Therefore, if they don't own them, they're not available to the creditor, the divorce. It's not a marital asset when they get into that situation. Why? Because they don't own it. It's really all about ownership. There's language in the trust about discretionary distributions, but it's really all about ownership. And folks, even if you're not worried about the divorce, right? Everything's going to be fine. But you love your grandkids, I think, as you mentioned, Chuck. Well, if this trust goes on and the children just take it as they need it, well, then it could grow over their lifetime. And when they die, because the parent had already died long ago, and an allocation of generation skipping tax exemption had been made to the trust, the growth in all these assets when the child dies, if they haven't taken it, they don't own it. And therefore, the government is not taxing it. And so we're able to skip a whole generation of taxation and get it to the grandkids tax-free. So, folks, that piece of it is staggering when you think about what the savings might be. In fact, you can't even really calculate it.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. Still some room on the phone lines here at 888-205-2263. So get your calls in so that you can speak with Todd about your estate planning questions. That number is 888-205-2263. We're going to take a quick break here, but when we return, it's going to be right to your calls with Todd. That number is 888-205-2263. One more time, 888-205-2263. Your calls with Todd when we return.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. You're listening to Ask Todd with Todd Lutsky on the Financial Exchange Radio Network.
Got a little bit more room for calls, so call 888-205-2263 if you got a question for Todd Lutsky. Again, that number is 888-205-2263 to ask your question to Todd Lutsky about your estate plan. Let's go to Chris in Maine, who has a question for Todd. Chris, you are on with Todd Lutsky.
Hi, Todd.
Hey, Chris.
So my mother's about 84. She owns 2 properties outright. They're both worth about $500,000. She also has somewhere around $600,000 in savings.
Mm-hmm.
She has 2 surviving sons, which we inherit everything.
Mm-hmm.
Right now, she has everything basically a simple 50-50, and we sort it out. With the 2 properties being of equal value, is there any point to her leaving one property to myself and one property to my other brother, or do we just leave it as 50-50? The other question is she would like to give some money to the grandkids, not a large amount. I guess, let's say $5,000 to $10,000 each. Should she do that now, or should that be in the will?
Well, so there's a lot of questions, and so let's just start with the very last one. I'll come back to the real estate in a minute, because the smaller item is the grandkids item, only because it's dollar amount smaller. I think she needs to, first of all these questions make it sound like, I don't want it to be your wish. It needs to be what she wants to do. So if she wants to leave money to grandkids, then the question is, how old are the grandkids? How responsible are they? And do we want them, when we pass, to get it right away? Or do we want to hold it in trust for them so that you kids, perhaps as trustee, can, make distributions out of the trust for them on a need-based situation, like, for health, education, welfare, and support, right? So, and again, if it's only 10 grand and that's probably not going to change their life, they're not worried about them blowing it, and they're old enough, well, then the trust can just say, upon death, allocate $10,000 to each of them paid out. Again, I think a trust is needed way more than a will here based on these things that you're talking about. Now, sticking with the grandkids, it might be that she says, you know what, for that kind of money, I want to be able to see them enjoy the money. Give it to them now. That way she can actually see them enjoy the money. And so this is really a question for her more so than for anyone else. And for that amount of money, there would also not be any gift tax concerns if she were to say, yes, I want them to see it now and enjoy it now. So again, under $19,000 per person per year, she doesn't even need to file a 709 gift tax return. It's simply ignored. So I hope that answers that part. Now, the bigger part is the real estate. Couple of things. One, certainly very happy to hear she hasn't given them away yet, whether it's one to you or one to your sibling. Giving it away during life is not a good idea. Unlike the small cash gifts, I'm okay with those. But giving away real estate that I'm guessing she bought a long time ago and could have a large built-in gain, right? If you give away that property to either of the kids while they're living, then you're sticking them with this built-in gain because they're going to get something called a carryover cost basis. So when they go to sell it, you, for that matter, Chris, would go to sell it, you would be stuck with that capital gain. Whereas if she dies owning it, we throw it into one of these trusts. Now, for her, I'd put it into an irrevocable trust. Sounds like there's not a real big estate tax concern here. She's under $2 million based on the numbers you gave me, and I'm assuming she's a Mass resident. We want to just make sure that they're protected from the cost of long-term care in the event she would get sick prior to passing. So one, don't give them away. Two, set up an irrevocable trust, throw them in there. Now, once they're in this irrevocable Medicaid trust, up to her again in terms of what that trust says when she dies. Do we want it to have a payout? Oh, divide equally to the kids, pay it out. Well, if we did that, there would be, when we do it at Cushing & Dolan, there's language in the trust that says, listen, we're going to sell these properties unless you both want them. See, now it's up to you kids, right? Whose head is where, who wants what, when. You never know geographically where a child's going to be. And so then what? Well, then you guys can decide. No, we don't want it, sell it, split the money. Or, oh, wait, I want this one and I don't, and the other sibling doesn't. Well, then the one who wants it can buy out the one who doesn't at fair market value. So again, everybody's getting the building that they want anyway. Or, as you guys said, you can always just work it out and say, I'll give you this building, you take this building, and go on your way. I like to leave language in there to allow the kids to not be stuck with real estate if they don't want it. So put that language in there. All that said, that's the way I would probably pitch it to the client, but I would still want to do what the client wants. If the client comes back and says, nope, I want property X to go to you and property Y to go to your sibling, so be it. We'll put that language in there. So hopefully that helps a little. Sorry, long-winded answer, I know, but a lot actually going on in that question. And folks, there's a lot going on in your estate plan as well. And that's why you need to get the guide. Back to the basics. If you've never done your planning, this is basically an engagement letter that I drafted, explaining a recommendation to a made-up client with kids and assets. Everything is laid out. It goes on to explain all the basic documents from powers of attorneys to healthcare proxies to your will and in detail. And then it goes on and explains the plan itself, which is in this case, the client wanted an irrevocable trust. So it explains how the irrevocable trust works from estate, gift, taxes, nursing home protection, accessibility, bloodline planning. It really gives you, who knows, it might be, if you put your family dynamics into this situation, you might say, this is the plan for me. Who knows? Either way, it's going to give you the information you need to begin your estate plan, what to think about prior to going to your attorney to start the planning. So get the guide, Back to the Basics, 866-848-5699 or legalexchangeshow.com. Again, 866-848-5699 or legalexchangeshow.com.
Todd, one other thing that I just want to touch on. We talked earlier about, kind of planning beyond the grave. What if someone is in a second or third marriage and they have children from prior marriages? How can trusts help to navigate who gets what after both spouses pass? Yeah, great question. Because again, think about Chris's call, right? When he was asking, who should get what assets, right? And that's just for a first marriage. And look at what we went through, right?
Sure. So, but remember, the trust can be designed to accommodate that. So at the end of the day, if you can accommodate a first marriage, you can certainly accommodate a second marriage. And again, there you're really going to need to talk to the client, say, hey, do you have kids from a prior marriage? And do you have kids from a prior marriage? And, are you close to all of them? Are you both close to all of them? Or are you only close to your own? These are the kind of questions that need to be sort of, ferreted out when you're drafting it. And if the case is, we are close to all of them and we'd like to, treat them equally, well, then it's easy. And then you say, okay, equally to all the kids. But you need to define in the document that the children, the word child, children, and issue shall mean children of a, regardless of parentage in there, it's going to be considered their child. So the child of one is the child of the other. So you got to make sure you define that, and then you can do it that way. Some people say, you know what, I came into this marriage with extremely different amounts of assets, and so maybe I brought 70% in and the spouse brought 30% in. Well, that might be a way of splitting it, right? I'm going to allocate 70% of the assets equally to my kids and 30% equally to the children from the other marriage. So there's many ways to think about it. I think the message here is simply get your planning done and learn how to do it.
Mr. Lutsky, thank you for joining us today.
Always a pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.